Hi, everyone. It's Grant Abbott speaking. I'm here with Tony Anamoulis. How are you going, Tony, today? How's Melbourne doing?
Good. Oh, Melbourne. Don't worry about Melbourne. Melbourne is just another. It's
Yeah, I heard you're
dreadful.
a bit muffled there, so you might just want to speak a bit clearer
Yeah,
into the microphone. But yeah, I heard Melbourne is pretty cold at the moment. It's actually snowing in the Dandenong, someone was saying.
yeah, it was actually. Yeah, it was snowing down there, and also it's like 5 degrees down here. At home, ducted heating's on, and doing what I do basically,
Yeah, which is
which I quite
fantastic.
enjoy. Yeah.
So yeah, you just sound a bit muffled. So make sure you get your voice there close to the microphone. So give it a bit of a yell. Give it the
Can
old
you?
Greek
Can
yell. Pretend you're going for one of your Greek soccer teams, Pathinos or something. So what we're
yeah.
looking today is, I mean, you got to have honestly, in these days, we've got to have a bit of fun around these sort of things. And what we're launching today is we have had out our LightYear Docs will, and also our LightYear Docs will with Testamentary Trust, which many of you have been using, which is great. A lot of people came back and said, well, does that mean I need to do a second will for the spouse, and can we just do mirror wills? Really, you'll see when we get into the case study, there's no such thing as mirror wills. You can't just go like this to that, because at some point in time, someone's actually going to die. So then you're going to have to revert and complete the other one's will as best as possible, which we'll look at. I want to focus in on that, or Tony and I are going to go through the process. So we've now bundled them up together, so it's very easy to do a will with Testamentary Trust, or just an ordinary will, and then do it for a couple spouses. We haven't put it into the moat yet. The moat is a monster, because I don't know if any of you have checked the moat, but and I'll have to do another training on it very shortly, maybe even next week. I'll just have to took my training schedule, because we've got it all expanded out until the end of the year. But effectively, the moat has now got the protector in it. So with the moat, you can do the protector. You can set up a fund, or more importantly, if you've got an existing self-managed super fund, you can upgrade the corporate trustee to leading member trusts, leading member SMSFs, which are absolutely crucial for asset protection, which we'll look at very shortly. It does your SMSF will, and also does a will with a testamentary trust, or just a basic will. So there's so much going on in there. It's really hard to build that also for the spouse. There's a couple of hacks I can show you, but let's leave that until next week. And my developer has a heart attack. I'm going to keep on adding extra documents in, and see when we get out that a little bit later on. So we're going to have a look at the system. We're going to play around with it. I'll have this recording, so you'll be able to go in and have a look at it. So we want to get to that playing around in the case study, but there's quite a bit of stuff we need to get through first. We all know Paul Clitheroe. Well, if you don't, he was a huge guy way back in the, they call it the noughties. He had the Money magazine. He was head of a financial planning firm called IPAC, sold out for a squillion dillion. Has done really well, but more than 50% of Australians don't have a will, which is really scary, because if you know the process, if you die intestate, each state has its own set rules as to where the assets are going. But the problem about that is, to get that going through the process takes a long time, and all estate planning does that, is that everything takes time. Like, for example, if you've got a will to get probate, it takes time. You've got to go Supreme Court into the probate division, and then you start getting costs. If you die intestate, the worst thing is you either go and get someone's nominated to the Supreme Court to look after the estate, or you end up with a public trustee, which is going to cost squillions. In fact, probably as much as Paul Clitheroe got out of IPAC. So the last thing we want to do is die intestate. Now, the problem about it is a lot of existing wills are really, they're just too old. Things have changed, circumstances have changed. You really need to go out, and for those of you here on the call, just go in and start to have a look at your own will, and does it really match the current times, particularly when we look at asset protection. And with COVID, obviously, death and disability being front and centre, not only for individuals but the whole family, it's an absolute crucial time to get in there. So, and you can see a number of lawyers are out there already starting to pitch to do wills, etc. Main thing though is from my perspective, and I've been very lucky to, get involved with Tony, as all of you will. I mean, we're pretty blessed to having this resource, which is for our LightYear Docs people. Is that SMSF has been my bag for a long time, and look, I love it to death. But again, it's there's an end game there. Is that with SMSF's a large amount of money sitting in the over 55 or the over 60 boomers market, or the generation before that, the war, or they call them the silent generation. But even those guys, there's only around about $350 billion, which is going to pass over the next 20 years. So we need to build completely separate processes for that, which I'll show you a little bit later on. It's not the subject of today because we want to get those spousal stuff out. But the big game is really the $3.2 trillion, which is going to cross generations in the next 20 years. And that's investment properties, commercial properties, companies, businesses. All of that is going to pass at some point in time down the track. And look, to be brutally honest, if you go back, I've got a great, shows you how what a nonger I am, but I've got a list of all the viruses and the potential pandemics that have come online in the last 20 years. And virtually every 2 or 3 years, we seem to have a pandemic. I don't know if you remember 2009, the swine flu, H1N1. We had SARS in 2002. The Zika virus, do you remember that one? Last year, 250 million pigs were killed was slaughtered in China with swine flu. So now we've got COVID, and so this is not going to stop. So we need to really get all of our clients and our own affairs in order, which are absolutely crucial. So how do we go about doing that? So what we can do is this is not an enduring power of attorney session. If you've got that, you can go on to our strategy center and look at it. But what I want to do is give you a bit of a heads up, bit of a refresh, just really quickly on some of the key terms that you're going to find in the LightYear Docs and the Abbott Mourly Wills. And we're going to go through that process very shortly. I'll do this, then I'll hand over to my mate Tony, who'll then take us through what the Legal Professions Act. I want to make sure that we don't step over the line and get the lawyers up in arms. You know what they're like. They love to have a bit of a challenge, particularly now that their revenue is virtually drying up because of COVID. What we need to do is make sure we stay on the right line and deliver a great result for our clients. And Tony will go through that process. We'll then go through a roadmap to success. And then I'm going to show you what the retail pricing is, what you should be charging for wills and testamentary trusts, and a couple of other documents as well. And then I'm going to get into a case study. We'll do that. So it's a jam-packed hour. So let's get going. First off, is a will it's a legal document, and it has to be legally valid. And Tony will talk about what he needs in order to, if he's going to provide sign off, what he needs in terms of identity checks, also in terms of mental capacity. For example, my dad, I could draft up a will now, give it to my dad, love him to death, but he's got dementia, so he has no mental capacity to make a will at this present point in time. But if you've got a legally valid binding will with a couple of signatures and witnesses and do all that, and there's a lot of interplay now, particularly obviously with Zoom conferencing. So Tony will go through that process, and for me, I think it's a lot better facility than actually getting them witnessed, because you can have everything recorded, you can see everything done on screen. It's just the best way of doing it. So I'm all for this big new wave we're going through, not with COVID, but this new digital interaction. And I think we need to embrace it. And all of you guys are innovators or early adopters. So that's what we're going to go through. And I want to give you exactly what needs to be done. So needs to, obviously, how your deceased estate is going to be distributed amongst family and charities or friends or whatever. So that's all sitting in a document. I could sit here now and I could write something in I might put my little LightYear Docs pad next to me. I could write something, get it signed, and bang, that would be a legally valid will. But obviously, we want to make sure we've got a bit more oomph in that. You can go down to the post office and you'll see there, you can get them, I think they're about $10, your own will packs. You know, they give you an ability to do whatever. You'll find a lot of the online sites, Clear Docs, you know, a lot of them have obviously wills. I know H&R Block are about to release quite a substantial package in terms of being able to do a wills online. I actually tried it but found it too hard personally. I've had a look at their Canadian system. Again, it's way too hard compared to ours. And then I also know that BGL came out with a wills process. And you'll go through, and what we'll see today, quite often, to be brutally honest, I would say 40 to 50%, I was going to say 60, 40 to 50% of your clients only need basic wills because most of their assets actually should be placed through a protector into a family protection trust. But let's not jump ahead of ourselves. Let's just get the basics down. So the executor is the person who's going to is going to actually administer the estate. Look at that second sentence. Family provisions claims are rife, $3.2 trillion out there. You know, the guys who are the workers' comp lawyers, the personal injury lawyers, they're going to sniff out and they're going to start making these family provisions claims because they're so wide. It calls any eligible person, which is spouse, ex-spouses, children, grandchildren. If grandchildren have been financially supported, then effectively they're right in the mix to make a claim on your estate. And if you do that, it's a very expensive process. So it'll take probably at least a year, a minimum a year, possibly 2 to 3 years, and up to 6 or 7 years if you have a look at the Taylor and versus Miller case over in Western Australia, where more than $500,000 in legal fees were scavenged from an estate worth only $600,000. So when we have a look at that, we've got to be very careful that the executor is someone who has a huge backbone. One thing I would put for all of you, don't be an executor of your client's estates. I'll talk about it a little bit later on. Be the advisor to the estate, because the problem is if you're the executor, I've seen it too often that the beneficiaries who feel that they've been left out will take a challenge at your fees. So if you're going to be executor, don't expect to get paid or you're going to be in huge strife. So why would you do it? Be the administrator, and then that's basically the case. So we're going to have a look at that a little later on. And when I mean administrator, the accountant or the planner to the estate to make sure it all goes to a point. Now, if you don't have an executor, then the court will appoint an administrator, or it may well be the public trustee. Again, as soon as we do that, that's a huge extension in time. So you're looking at throwing an extra, 5 or 6 months onto the process. Beneficiary is basically anyone who's going to get a gift. We prefer to use the word gift these days, but if you want to go back and call it a bequest, which is a very old term, that's fine. Probate is once someone dies, we go to the probate division of the Supreme Court in their relevant states. And then what happens is they verify the will as being the last will and testament, and then the executor can start to pile on and do their stuff from that date. But the probate, the process for the probate, can take anywhere from 3 months upwards. So we've got to be really careful. If that last will and testament is contested, so it's saying that they weren't of sound mind or that, you're looking at a couple of years and probably $100,000 in legal fees. Unfortunately, everything has to go through the Supreme Court. The initial administration, so we've got the probate. So what happens is then the executor or the administrator steps in, pays off all the taxes, pays off all, listen to this, pays off all the debts of the estate or the testator. So, for example, if you're doing the protector where we've done a gift and loan back to the testator, then the trustee of the family protection or the leading member trust needs to poke their head up, and that will be obviously the next in line leading member, poke their head up, and the trustee of that trust will then call in that loan, and then the executor will obviously pay that loan, and that money will be then swept out of the estate, which again, as I said, probably around about 40 to 50% of your clients, if it looks as though it's going to be a challenge, would be better off to have these family protection trusts set up from the start. So do the initial administration, pay funeral expenses, blah, 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 and, essentially we're off and running. So Then we go down to specific gifts, which is my preference. So the process is we get, obviously there's someone's got to die first. That's the first step. Next one is the executor gets probate, but between that is you as the administrator or the person, the advisor to the estate, will get everything moving, help them get probate. Once you get probate, you do the initial administration, then you sit down and have a look, is there any specific gifts? So, for example, are you going to give your children $100,000 each, for example? Or is a property that's sitting in the estate, is that going to go to little Johnny? So that's a specific gift as opposed to residual. Now, once all the gifts are all paid out, and we have to work out who's going to pay, for example, if I'm transferring a property out of the estate to little Johnny, then who's going to pay any taxes or stamp duties? There may be exemptions, but who's going to pay for the costs of all of that? And remember, part of the costs are obviously going to be your advisory costs. Is it the estate, or is it actually the person receiving the gift who's actually going to look after that? Now, whatever's left over is what we call the residual estate or the remainder, and then that starts to go through a chain of beneficiaries. So we have the principal beneficiary or the principal beneficiaries. You'll generally see when we get down to basic spousal wills that obviously it's going to be the spouse who's going to be the main beneficiary or the principal beneficiary. Now, if they're not alive, we have to work out, well, you can't just stop there. We need to work out who's going to be the second beneficiary. And that may well be the children or someone else. And then who is going to be the tertiary or the third beneficiary. So again, we've got to prepare for the worst case scenario. Have a look at what happened with the Beirut bomb there. I don't know if you saw that, but oh my God, that looked like an atom bomb. That looked like a nuclear explosion. But, suddenly if a family's wiped out, who's going to end up with there? And then we need a default. And you'll see that with the default in all of our LightYear docs, we're very, very heavy on bloodline or lineage, so that if there's no one alive, then obviously, and that includes the executors, you'll need a court-appointed administrator, and they'll have to go around and start to look for bloodline only. So it's bloodline only rather than charities. But of course, you can put charities in there quite easily if you want. Now, it's a big thing over in the US, not so much here in Australia, but it's something you've got to look at, is that particularly when you do spousal wills, like, one partner giving to another, that may impact, particularly if they're over age 65 in receipt of Centrelink, it may impact on Social Security or have tax consequences. So at any point in time, the beneficiary may renounce their gift. So effectively, the executor says, look, you're up for this. And they might say, no, I don't want that. And so then it goes back into the pot. And if it goes back into the pot, then it'll end up in that residual estate. So we go down, if the principal beneficiary says, okay, well, I've got three assets here, but I don't want this one, they'll keep the two. Then it goes down to the secondary beneficiaries, if that makes sense. So it's a logical snakes and ladders that we're really working from here. With a testamentary trust, obviously, we utilise those, and what they're there for is asset protection, but they don't protect you against a family provisions claim. Once someone dies, then the family provisions claim sits up. But importantly, like any trust, they do provide asset protection. If there's no family provisions claim, they help protect in terms of potentially family law if it's structured correctly. Certainly impacts in the event that there may well be a litigation against the individual concerned. Absolutely want to have a mandatory one in case we've got a bankrupt there. So we've got a lot of those elements there. If they're done correctly, also we've got an ability section. Obviously, any minor is a person who's an excluded person and is taxed at penalty tax rates, but an exemption under Section 102 AG arises in relation to wills. The only problem you've got now is that there's been new testamentary trust laws which took effect a little while ago that now make it very difficult, particularly in relation to superannuation, transferring it over and putting into a super proceeds trust. Hence why we've built the Smsf Death Benefits Trust. Hey, we're innovators. Let's go to the final one. Default, as I said, we're really geared toward the bloodline and lineage. Lineage are your direct descendants, so it's easy to pick who they are. Bloodline, so for example, my children, the children of my children and all of my bloodline, also they have to have the same DNA, they're my lineage. Whereas if I have a look at it, bloodline, so classic one would be the Queen. So Queen Elizabeth, obviously, if we have a look, Harry is lineage, George is lineage. You know who fits in there. Obviously, Meghan is not lineage; she's not bloodline, so she's out of the game altogether. So we want to do that. We want to start building these royal wills and all that for our clients. But obviously, her sister, Princess Margaret, and all her kin, they're bloodline, but they're not lineage. So we need to have a look at the difference there and explain that to the client. SMSF wills. So I'm just going a little bit further. You'll find that generally, if you go to a legal firm and get your wills done up, effectively from that process, what will happen is the superannuation ends up into the estate, whereupon it may end up in a super proceeds trust, which, as I said, at the moment is problematical. In fact, I saw one of I think it's a Brent Backhouse from DBA, who has suggested that all testamentary trusts with super proceeds on the death should actually go and get a binding nomination, not a binding nomination, binding ruling from the commissioner, which would even stop things further. My preference is obviously to do an SMSF will, which has specific gifts and instructions. In fact, there's 6 different directions in there. And again, you would be an advisor to that. It's a contract between the testator member and also the trustee of the SMSF as to what is going to happen. Out of that, you'll find if you're using our SMSF will, and I'm not going to look at that today, you can create an SMSF death benefits trust. You can either mandatory create it, or the trustee of the super fund can create that. Importantly, from that perspective, is that when we do the SMSF Death Benefits Trust, it actually does have that Section 102 AG, and it's not impacted by those recent testamentary trust rules, which is great. So again, the minors are taxed at adults. So it's for me, it's a great way. But look, at the end of the day, if you've got minors there, it's probably better off to provide them with a pension, because if you're looking at paying a pension, the worst case scenario is it's assessable with a 15% tax offset. So again, they're not taxed. They're one of the accepted rules to minors being taxed at penalty rate. So that's preferable, but SMSF Death Benefits Trust is great for adult children and their children. The Family Protection Leading Member Trust, these are ones you'll see will come out later on, but these are basically what we call inter vivos trusts. So that at the end of the day, if I've done the protector, I'm housing everything into one of these, and they're definitely not trading trusts, they're just straight investment trusts. That doesn't look as though there's ever going to be litigation against it, so on and so forth. Then in that instance, what happens is we're going to have a position whereby those assets are residing in there. They don't even fall as part of the estate. One of the things is, if we have a look at it for a lot of SMSFs where they've gone over the T-bar and they've got running an accumulation account, ideally it might even be worthwhile considering, do your spreadsheet, take those assets out of the SMSF on the accumulation side, put them into a leading member trust, and then what happens is they'll go in essentially tax-free, so settle it there rather than wait for death, where obviously there's a couple of bites at the cherry if it's in the accumulation side, that with CGT on the assets coming out, and then potentially taxable component will be taxed at 17%. For adult beneficiary. So a better way is to think cleverly and actually do what we call an inter vivos trust. And again, for you, the final one here is the advisor to the estate. That's the best process. I've seen a number of lawyers charge up to $40,000 or $50,000 for being the advisors to the estate. So don't be the executor or the administrator, simply be the advisor. It's a much better process there for that. So let's move on here and have a look at the law as to, again, we want to be very careful about the various uniform laws across Australia in terms of providing legal service. So Tony, do you want to take us through what is a legal service, and more importantly, what is not a legal service, so everyone's got a really clear line there?
Yeah, hi everyone. Let me start off with basically, now, pursuant to the Legal Profession Act.
You might need to, can you talk in your microphone a bit better? It's just a bit muffled there. It sounds as though it's under your shirt.
Can you hear me now?
Yeah, a bit better. Yeah, that's much better.
Much better? Okay,
yeah, much better.
Fabulous. Oh, excellent. All right, so what it does is basically prohibits, let's start off with this. Let's start off with the Legal Profession Uniform Law Replication Act, which is in Victoria, and there's a cross to that in New South Wales, which prohibits a person from engaging in legal practice or representing or advertising that the person is qualified to engage in legal practice unless that person is an Australian legal practitioner and a person who holds a current legal practicing certificate, right? So, in a case, there was a case of Cornell versus Nagal, which was back in 1995 in Victoria, and it broadly classified legal practice as doing something which, in order that the public might be adequately protected, is required to be done only by those who have the necessary training and experience or expertise in the law, basically, right? So in other words, a person may have engaged in unqualified legal practice where that person does not hold a current practicing certificate, or either provide the legal services or behaves in a way which creates a reasonable inference that the person is qualified to provide legal services. So, actions that are legal services and for the provision of legal advice is drawing and drafting documents, giving advice, appearing in court, or using the name of a barrister, solicitor, or an Australian legal practitioner, or any other name used to describe someone who is qualified to engage legal practice. Okay, that's my job. Okay, now actions basically that don't qualify as legal services or legal advice is, if we run off to the next slide, is undertaking work in association with a law firm will not necessarily constitute engaging in legal practice. Examples: clerical, administrative tasks, such as inserting parties' names in a document, as you guys may well do. Selling of legal documents, why? Or advising of incidental legal requirements by a person in the pursuit of an occupation other than law, such as tax agents advising on the requirements of tax legislation, right?
And I think that's pretty important, because there's actually been a couple of cases, believe it or not, the reverse, where I know in 2012 a lawyer was actually held to have breached, I think it was the Real Estate Agents Act, because although they're able to do the conveyancing aspect, they were doing a lot more than that, and they needed a real estate license. They argued that lawyers can do everything. And even out of that, there was an argument that an accountant should not be giving tax advice at all, because that should only be done by a lawyer, which obviously didn't last that long from that perspective. So what we've got here is, you just want to take us through, and you're going to get these slides, you're going to get the recording, you're going to get all Tony's details. We've got a 5-step process for you in terms of estate planning. I'll do the first couple of steps and we'll go through it. So you're going to find, so you're going to find on the LightYear Docs site a data capture. So there's a letter there to the client, which you can send emails out, which I'd strongly advise you to do, with a data capture. I know Tim Munro's also got one as well. And then from that perspective, send it out to the client and let them complete that data capture. Again, we're making sure we're fitting in that data capture, that administrative service side. And then what we'll do is you'll get that data capture, you'll then build the will, the EPOA, and any other estate planning documents if required by the client. Now, the next stage is, and this is where Tony gets involved. So if it's just a basic will, etc., you can go down that process, because embedded into the system is our proprietary legal information. So you can only put in data, you can't go and insert or change any of the clauses, which is important. But steps 3, 4, or 5, if you've got potential clients and you want help from our side of the equation, from Abbott Mourly, getting Tony involved, it's a very seamless and inexpensive process. So do you want to take us through that 3, 4, and 5 in your roadmap there, Tony?
Yeah. So in step number 3, after the data capture has been done and you've built the will basically, then and then the estate planning documents are actually sent to me for review. Okay, so once I've reviewed them, then we set up the first Zoom conference with the advisor and the client to obtain any final instructions relating to any amendments to the documents, which is important, right? We may have to go through this process, that step 4 process, you know, a few times so we can get the documents correct in accordance with the client's instructions, okay? So that's what step 4 is all about. And then we'll move on to step 5. After we've obtained the final instructions, the amendments have been done, the client is happy, then we actually finalise the documents. We're at a signing stage. So therefore, AM finalises the documents, and then they're sent back to the client for final review. And then a second Zoom comes in, basically, which is the signing and the witnessing of those documents. Okay? So if you follow the roadmap as it is, what we're trying to do is simplify the process for you guys, where the advisor or the accountant or the planner and us are working in conjunction together with the client's needs in order to achieve the objectives and those goals for him in a simplified way, okay?
And I think it's an important process for that is to understand that that data capture, that preparation, you'll still charge the client. I'm going to show you the pricing there. But importantly, the document is actually, at the end of the document is provided by Abbott and Mourly, so it comes under our professional indemnity. So it's our professional indemnity, which is absolutely crucial. And I love that final process because if you've seen Tony work, you'll go through, he discusses it. So then there's a sign-off, and then from the sign-off, he can witness it. Everything's recorded on a Zoom. He can then witness it because he obviously can take control, remote control of your desktop and actually sign on the spot. Then everything gets sent down to Tony and then goes into the vault. That's correct, isn't it?
Yep, that's correct. Or the other alternative is basically on the day that we do the Zoom, on that particular day, say for instance for today, we sign off on an EPOA today, then that EPOA is sent via express post back to me. I receive it, that is the originals. I sign it on the day that I saw the client, which is today. I sign it off. I make photocopies of it. I send back the originals with 2 certified copies. The original goes back to the client. The second copy goes to the advisor. And obviously, we keep a copy on our file, and that completes the matter. Easy.
So that's perfect. So what I've got up here, there's a couple of things there. If you're doing a really uncomplicated will, and when I talk about here, including a 30-minute personal consultation, that's you. So these are the typical fees that a suburban lawyer would charge. So $7.95 for one will, $11.50 for 2, so spousal wills. So if it's a basic one, really simple one, particularly if you've put in place a protector, you're looking at $11.50, but the pricing is in your hands. Now, once we start to get up into testamentary trusts, they get a bit complex. There's been marriages before, or one of the children's going to be left out of the wills. Anything that you feel essentially that may get a family provisions challenge, obviously go down the protector. But the other one is if you're starting to do testamentary trusts, special disability trusts, a lot of enduring guardians and stuff like that, then what's the other one that you just came up? Oh, a child protection trust, which Tony came up with the other day, which is very popular, and we're going to start to build that into the system. Then you're looking at a more expensive process. So it's $18.50 for one will, $2,600 for 2 wills. But again, these are just our suggested retail fees. You can charge whatever you want. And I've got there, and I'll leave these. These are on the slides. So you've got your enduring power of attorneys, appointment of medical treatment decision maker, SMSF will again. So you can actually say, okay, I'm going to do an enduring power of attorney, SMSF will, wills with testamentary trust, and for spouse, so that would be like 2,600. That would be 3,150, and then that's $4,300 is the actual retail fee, which we've done in a couple of cases at Abbott Mourly. Then in that instance, what will happen is you'll charge, maybe tell the client you're going to charge them $3,000, $2,900. Now, for the process for the sign off, if I go back to what Tony was saying, for where we get involved, remember, you're one, get the data capture, two, actually build the document, send the document into Tony, book that meeting, and then we get up to four, and I'll generally be on a lot of those meetings as well, and then five. So the process there is $495 for a single will and EPOA, and $795 for a couple will and EPOA. Again, it's a great pricing system. You use that for when we're up around that, and you cascade your wills. So you find generally, Tony, don't they do the wills, the EPOA and SMSF will all together. So it works out. I mean, you're obviously going to get a maximum. So it's a great process for your clients. Funnily enough, when we had a look at H&R Block, I said we were very close to getting involved with them, but it was just too hard. We don't really want to go that business to consumer. We want to facilitate the process of helping you guys go to your end clients and building it. But H&R Block went out to their clients, and on their review, they asked if they'd like to have wills, and it came back with a 75% resounding yes. So obviously it's a prime time to do it. So let's go through and have a look at a bit of a case study here. So I've got John has been married to Sally for 40 years, both grey nomads in their 60s. Can't come to Queensland, obviously, at the moment. But anyway, the last will they did was 20 years ago. So that's well and truly out of date. It's crazy. They own a house jointly with no debt and currently valued at $600, plus they have $200K on a term deposit. So just on that side is when, obviously, if John dies first, then the house goes to Sally. But it still means we need to work out, for the last one standing, we either keep the will together, but what I'd recommend, if John dies or Sally dies first, you go back and revisit the will. The good thing about it is the will you're doing sits on the LightYear Docs system, so it's very easy to go back and tweak and reconfigure it. In fact, you could virtually do a new will along with new deeds each and every year if need be, or definitely go down the track later on is that if you're going through this process, start looking at the children. So, for example, I've got Max here, who's got a printing business. If you're going to do John and Sally, and you're not looking after Max yourself, make sure you tie it in and let John and Sally shout Max a will for his family. So the $200K term deposit we're going to have to look at. They own a commercial property worth 1.2, which their son Max runs a printing business from. This used to be John's, but he gave it to Max by way of a transfer of shares to Max's trust. Max pays a peppercorn, so the business he gave to Max. Max pays a peppercorn rent of $1,000 per annum, so that wouldn't be good if it was in a self-managed super fund, because obviously it'd be a breach of the Nagal rules, and it's definitely Section 109. And it's been promised a property when John and Sally die. So that to me, when I sniff around there, some of the things I'm looking at is what's going to happen with that $200K. Last will was 20 years ago. That's stuff. I've got this. I've got the property is going to go to Max, so I want to do a specific gift. So then I'm thinking, well, probably I might do that through a testamentary trust, because we have a look at the next one. John and Sally don't like Max's wife, Samantha, but love their two young grandchildren, Ben and William. So I'm building a bloodline testamentary trust in that one. So that's my thought there. I'm going to take you through the basic wills, and then we'll go through the, actually what I'll do is I'll take you through the testamentary trust one. The youngest daughter, Sarah, is age 40, been married 3 times, run 2 businesses in the ground with John and Sally, losing $500,000 as guarantors in the process. So she's no children, lives a different lifestyle, which John and Sally do not approve of. I'm not going to gossip here, but I won't go into what it is, but it's definitely internet-based. And so they're estranged. She's threatened to challenge any will. So obviously that's a super red herring there around family provisions. I'm going to build the testamentary trust, but then I'm going to come back and give you a different idea. Now, John and Sally, whoever dies first, want to give 20 grand each to each of the children and also to their grandchildren alive at that present point in time. Now, off to the side, they've got an Smsf with $500,000 each in it, with a corporate trustee and 6 shares in the corporate trustee, each held by both of them. Their BDBN was completed at the same time as the will and directs all super into the estate. So actually look at a BDBN that was like, oh my gosh, that's 20 years ago. So we need to do that. So what I'm going to do is bounce out of here and we'll go up to the LightYear Docs site. Ask me any questions as we go through. I'm going to go straight into here and then I'm going to just put in LYD will. That's easy. I could have just gone straight into, the estate planning era. But you'll see here LYD will with Testamentary Trust. While I'm doing that in a second, do you want to, Tony, so I'm going to pull up the Testamentary Trust. We start the document. You can see I'm a strategist. I'm just going to put that into our Abbott test folder, start that up, and I'm going to do the Smith Wills. And you see it's going to be really easy. So I'm just going to call this the Smith Wills. Now, it's not going to be mutual wills because they're not going to be exactly the same. They may well be, but now if you're doing this, use the Abbott Mourly logo from a legal perspective. While I just build the common parties, were absolutely crucial in this instance. Tony, do you just want to go through and talk to everyone about what's happening with our recent thing with Moore Rowlands, Asia Pacific?
Yeah, Moore Rowlands, very exciting times. I think there's going to be a press release. It's going to be released out on Friday. And yeah, so we've actually, I've been trying to do this deal with Moore Rowlands International since January of this year. I've been talking to the Secretary General in that regard, and we finally signed off on an agreement to become a member of the Moore Rowlands Group International, which is basically a brand in itself. It's based in the Asia Pacific region. We are the only Australian legal arm who will be providing services to about a dozen international accounting firms internationally over in the Asia Pacific region. So it's pretty good stuff that's going to come out of this. So and there's also some other little bits and pieces that we're
working on a couple of international wills as well.
Yeah, so I'm modelling out. This is the other project that I said that I last said that I'm modelling out basically some international wills, and that'll be, I don't know, that'll be released in due course, maybe, I don't know, probably about a month's time, 2 months' time. You know, it's a big project, so just takes a little bit of time to draft it out. What else?
Perfect.
Yeah, so it's all exciting stuff, and there'll be a press release from AM on Friday, basically, that what's going on with Moore Rowlands International. So the only Australian legal group, or the only Australian legal firm to become the only participant in that group, basically. So very happy about that, and you'll see more of that in the coming weeks, basically. So it's all good.
So you can see what I've done while Tony is been talking is I've just gone through the process, and this is the most important thing you can do. Forget about the rest. This is the most important because essentially what I do is I need to put in all the common parties. I've got John in there, 5 Smith Street, Sally, the spouse. I've got Max, the son. Remember, they're going to get the property. I've got Bill, his son, Ben, his son. Haven't got Samantha, you know, the one that John and Sally don't like that much. We've got Sarah, who's the ne'er-do-well. I think her name's Sarah. Good thing about it is you can go around and change these things. What did I give her name as? Yeah, Sarah. So got Sarah, the ne'er-do-well, who's sitting in there. I've also put in Jeff Jones, the best mate, and he's potentially going to go in as executor. So you've done your data capture. You know, you're not overly, you know, if something happens to John, you know, if there's going to be a family challenge, which there, you know, if you have a look at Sarah, she's already poked her head up and said, I'm going to challenge it. So, you know, is Sally the best person to act as the executor? So let's just go through. Is there a life interest? No, we'll assume not. If there was a property that was held by John or as tenants in common, then there could be a life interest going to Sally, but we've got no there. But just notice there's no such thing as, we haven't built life interest into the basic will. So if you're looking at a life interest, and it could be for a child or it could be for the spouse, then you're going to go, your go-to is the will with Testamentary Trust. Would you like to make another will for the spouse? Yes. So watch what happens on the left-hand side. I go bingo, bango, bongo, and a whole lot of other stuff pops up. Now, this is important for you, is that are you an accountant or estate planning advisor preparing this document? So we've got our data capture in there. We put in the name of your firm, Super Financial Planners. We go in there. Absolutely crucial to put that in. If you don't tick any of these boxes, what happens is it comes up and leaves a blank field. So what we've got there is, you'll see when we get around to it, and I'll rush through this really quickly, there's 2 letters of advice provided by Abbott Mourly in relation to all wills and wills with Testamentary Trusts. One is a general letter of advice around the provision of the will by Abbott Mourly lawyers. And more importantly, from that perspective, is that you have helped, or your firm, Lamphy Super Financial Planners, has helped in the process of effectively getting the data capture and helping build this and providing estate planning advice, etc. Again, there's nothing wrong with you providing estate planning advice or tax advice, etc. So we've done the general. That's all A-OK. We go down to the testator. I'm just going to rip through this. It's obviously John. Who's the advisor? So we need to put this in. I've got put that in there. The executor. So I'm going to go. Obviously, this is doing for John. So I'm going to bin Sally. Sorry about that. So that's the son. And then what I'm going to do is, I could do that jointly, and what I might do is I might put the best mate in there. So I'll just put colleague in there. Might as well put best mate. So we'll put that in there. Successor executor, if both of those guys are dead, then what we'll do is we'll put in Sally in that instance. Second successor, I'm just going to go no. So we could put in a second successor, but remember we've got Max and Jeff. If Max is not alive, then Jeff sits in, and vice versa. Then it goes to Sally, if that's the case. Now, because Max and Jeff have both tied vote inside the document, I'm going to choose Max as the binding vote. Now, is there a specific bequest? Absolutely yes. So what I've got there is, in that specific bequest, I've got a position there that there's obviously a concern in relation to the bequest. Who's going to pay for the fees? Let's go for the estate. I could make the beneficiary. So now I go down to the gifts. I love the gifts. So that's easy. So it's just going to Max, who's the child, and the asset in question is the commercial property at Manly Vale, New South Wales, housing the printing business. So I put that in, and you can see there effectively what I've got. That's a specific gift. Now, every time, because I'm using the Testamentary Trust, you're going to see, do you want to go into Testamentary Trust? Yes. So I just press yes, and up pops. So is the main estate beneficiary the beneficiary of the Testamentary Trust? So is Max the beneficiary? Yes, of course. We can exclude it. Do you want the second beneficiary? So the second line of beneficiaries, and we're building this, we're talking about the trust now, not the will. We're talking about the trust. So the second beneficiaries in the trust, do you want them to be blood or lineage? Yes. Otherwise, what would happen is Samantha ends up potentially as a beneficiary. So she's about to be excluded. Are there any other related entities that primary beneficiary may have an interest in trusted company? Yes, because obviously he's got his printing business. Is the primary beneficiary the appointor? Yes. And then we can put in there, this is quite useful, we might put in there, no beneficiary, if I could spell, no beneficiary under the age of 25 is to receive a capital sum unless they are disabled. Okay, so I've done that, and then I go around to the next. This is a nice little tweak that we've actually put into the system. When we started to have a look at that, and I'll come back to you, Darren, around drafting of legal documents, why we'll have a look at this, and Tony will have a chat about that in a second. So social media accounts, what will happen with the social media? Essentially, then it can, we'll go, yes, early social media. We can go to Max Smith. We then go down to the principal beneficiary. So we've done the bequest there. Actually, I forgot the specific gifts. So I need to add another. Did anyone remember what I forgot to add another? And importantly, all of this stuff is taken out of the data capture that's been provided by the client, data capture. If it gets too down and detailed, then effectively that's where we engage Tony. Again, you do it up to a certain period from the data capture, and then Tony can work on doing the rest. So we've got Max Smith there, who is the child, and they are to receive $20,000. Is there a testamentary trust? No. So then I've got to add a no, and then I've got to add another. So the next one is Bill Smith, grandchild. He's going to get $20,000, and he'll be pretty happy with his grandpa there. So is it going to be no? Then we're going to add another. So Ben Smith, grandchild, $20,000. And this is all coming off the data capture. No. And then add another. Remember, even Sarah is going to, oh, sorry, silly me. Sarah Smith, grandchild, oh, sorry, child, is going to get $20,000. Do you want to go into testamentary trust? No. If it was more, if it's like $100,000, absolutely, I'll put it into a testamentary trust. In fact, what I'll do is I'll just jump this up here. I'll make this $100,000 just to show you what can be done. So this is going to Sarah. Remember the ne'er-do-well? Absolutely. Do you want to go into testamentary trust? Is the main beneficiary? Yes. Yes, blood on lineage. No. Is the primary beneficiary the appointor? No. And Max Smith is to be the trustee of the Testamentary Trust for Sarah for life. Okay, so what we've done is we've actually just taken her out of the equation. So you can see I've actually done all those specific gifts, built a testamentary trust out of the one of them. Secondary beneficiaries, yes. So if no one's alive, then what we're going to do is we're going to make it Max, and that is the son. We'll give him, again, the client says 75%, Sarah's been looked after. Now we've then got 5 questions. If he's not alive, who's it to go to? So it can go to a surviving secondary beneficiary in equal proportions to be paid to the tertiary beneficiary. Does it want to go in the testamentary trust? I'm going to say this one, yes. So I'm just going to follow the same terms as we did before. Is a spouse? No. Do you want a secondary beneficiary? Yes. Yes. Is the main beneficiary appointed? Yes. And then what I can do is I'll then just go into, if I have a look at Max, I've got no there. Sorry, I'll have a look at, yeah, look, that's fine for that. Sorry, I've got 2 Max Smiths. What did I do there? Okay, so I'll just go there. and then I've got Max the secondary beneficiary, and I'll just put that there. Now, why have I got 2 Max Smiths? Commercial property, and then, oh, that's right, he got $20,000 as well. So what I'm going to do there is I don't need those 2. I'm going to take that Max Smith out. How do I delete that repetition? All I do is go, see this little button up the top? I go delete repetition, and then I go back to Max, and I'm going to put also there $20,000. So thank you for Tony for messaging me on that one. And then I go through my tertiary beneficiary. No, look, if no one's there. Child guardianship, nope, but that would be important for Max. Is there any pet guardianship? Well, yes. Name of the guardian, Max Smith. Cat, name it, Tinkles. And then we'll put 5 years pet insurance from the estate. So that's okay. Funeral wishes, yes. Cremated and ashes scattered over the 12th hole at Sydney Golf Club. Okay, so then we go down that. So that's it. So that's Max done. I'm going to be about another 10 minutes. So if you're around, stay around. If not, this recording will be out a little bit later on. So we've got the spouse's will. Is there life interest? No. Yes. Remember, we did all this before. So this is land fee. Also land fee. There's a land fee super financial planning, and such a good firm, that one too. Testator, we're doing the spouse, which is Sally. So again, land fee, super financial planning. I then go down to the executor. Now what I'm going to do is put in place John Smith, who's the spouse. Successor executor, I'm going to make it Max. Add another, I'm then going to make that Jeff Jones. So that's okay. Second successor, no, I'm not going to worry about that one. So I'm going to go no. Make sure you tick boxes. Binding vote is Max Boobman the second. Specific gifts, is there a specific request? Yes. If we have a look at the estate will pay. So then if we go down and we have a look at the gifts, again, it's got to be the commercial property. Now they own it jointly. So the question is, with that commercial property, is it just one dies if it's jointly? Because what will happen is it'll end up going over to Sally. So if I go back to these are one of the things I'd have to tweak. So again, I'm going to put Max, who's the child. We've got 2 assets there, is $20,000. And then I tick there, and then I've got Max up here. And I've got the commercial property. Then I'll go down there, put that in there. I'm going to go back up here again. Max Smith, the gifts. I'm just going to pull this little bit here. No beneficiary C. I'll take that down there. As you can see, you can actually do this, believe it or not. I've done it a number of times where, remember, we're going to do a testamentary trust. Yes, yes. Yes. I've done this a number of times where you can actually do this with a client. You don't even need to do a data capture, just ask them the questions. Now I'm assuming there is, for this one, I'll just go no, because she hasn't got any social media. Principal beneficiary, I'm going to look at the principal beneficiary. While I'm doing this webinar is going to be obviously John Smith, spouse, 100% for that. Now, if something goes wrong there, where is it going to go to? We'll just go to the secondary beneficiary. In fact, I need to go back up and just check. I didn't do the principal beneficiary. Is going to be Sally. Spouse, 100%. And then we're going to pay to the secondary beneficiaries. Do we want to go in testamentary trust? No. So I go back. See, again, it's good because you can go back in and you can check. Secondary beneficiary, is a secondary beneficiary? Yes. Again, we're going to make it Max Smith. relation to testator is son, 75%. And then it goes to their children held on. So I'm going to go no to testamentary trust and just go straight to the one there. Add another. So then I've got Sarah. She is the daughter. She's to get 25%. Now, if she's not alive, then it's to be paid to any bloodline beneficiary. Do you want to go into testamentary trust? For this one, we'll just say no because, you know, mum likes it. That's why there's not always mirror wills. I think that's pretty important there. So secondary beneficiary, you can see here, I got two caught up and I forgot to put in the other one, which is Sarah. And we've got there is the daughter. She's not alive, then it's to go to any other bloodline. Do we want to go testamentary trust? No. So again, I can work out what this is. We've got the tertiary, no. Child guardianship, no. You can see here I didn't press the button there. So no. Child guardianship, no. Pet guardianship, no. And then funeral wishes, and we'll have none there. So now I've completed the whole box and dice there. So I just finished that off, and that will now prepare the documents there, which is really crucial. So if we're going to have a look, Tony, if you're just around, I know a few people have had to jump off, unfortunately, but where we go into this one here, effectively, it's quite a sophisticated one. And certainly here, if it's a basic will and we're just doing basic data capture, probably not. But here we've got a challenge. So this would definitely go through the 5-step process that we talked about. Would that be correct?
Correct. I'm correct. Absolutely. So all you're doing is basically you do the first 2 steps as you've done. And what happens after that, it comes to me. You send it off to me. I review it. I have the Zooms with the client. I ask him the questions. I ask him whether there should be amendments made on the document. Which
for Sarah, Testamentary Trust, all of that sort of stuff. So that's where if you're going to get into that.
Happens.
Yeah, I know. I've seen it. It happens. There's actually it's scary. We did have one where the client wanted to pay out the child. So like a Sarah, they wanted to actually pay them, what was a couple of $100,000 to keep them quiet. So we had to build a separate contract so they wouldn't make a claim on the estate under family provisions. So you can see here, we've got...
No, that's all right. Kev, I'll have a bit of a yarn after this.
So what we've got there is we've got our general letters of advice. You've got your last will and testament. This is for John Smith. We've got obviously Max and Jeff Jones, but Max takes the binding vote. And if they're not around, then Sally takes over. Ongoing trustees are the executor for any testamentary trust, super proceeds trust, except, you know, we have to watch out for that. Preparation of advice, as I said, super wouldn't go in there. SMSFs would actually be quite a separate thing as well. All the initial administration, remember we talked about that, that's all contained in this. Beneficiaries, the estater, the spouse. We look at specific bequests. So here's Max Smith's advisement by 30 days to take a full interest in the following assets: commercial property at Manly Vale. This entitlement is to be automatically transferred into a testamentary trust. And these are all the T's and C's, which you're going to build that testamentary trust on the death anyway. So when we have a look at that, we've then got the grandchildren getting 20 grand, Sarah gets 100, but hers goes straight into a testamentary trust, which we talked about. Max is the trustee. Social media accounts go to Max Smith. We then go, whatever's left over goes to Sally Smith. But if she's not alive, it goes to the secondary beneficiaries. And then what we've got, if principal beneficiary is live, goes to Max and also daughter there. And obviously what I've done is, you can see when I've done this, I'd have to go back and relaunch. I haven't put a percentage there. So I just need to go back, relaunch, put it in. And again, so there's quite a lot of stuff that would then go over to Tony. Funeral wishes, you can see there on the 12th hole of the Royal Sydney Golf Club. Specific powers, pet guardianship for poor old cat Tinkles. And then we go down, and then we've done Sally's one. So the executor, the witness will actually end up being Tony. Need to sign each and every page, and we can do that digitally, or you can do that wet. So then again, here's we're going into Sally's. She's got that general letter of advice. And then we go down is the last will and testament for Sally Smith. So it's all the stuff, but notice how it's not a mirror because there's a few different terms and things that we've changed. And we need to work that out. And that's where Tony comes in from that process. So just want to have a quick chat about that one, Tony. And that
that's what it is. If you go through the 5-step process, the advisor or the accountant or planner goes through the first 2 steps, right? And then we take over 3, 4, and 5, and maybe 6 somewhere. That 6 may be, fiddling around basically with a document in terms of, any further amendments that he wants done or she wants done to the for estate planning documents or whatever. But 3, 4, and 5 is our job because I'm the lawyer. I've drafted the documents, right? Step 1 and 2 is just data collection, interview process. You're gathering the intelligence basically through the data capture in order to give it to me basically at step 3. That's what you're doing, okay? And just one thing, just to make you feel a little bit more comfortable, right? The documents have been reviewed and signed off by Abbott Mourly, okay?
Yeah, particularly
at no time.
Yeah, so go on. Yeah. At no time you actually provided legal advice.
Yeah, at no time, due to the inbuilt legal protection and security measures, can the user change or amend a document on the LightYear platform. Hence the reason why when the will or the estate planning documents spit out, they come in PDF format. Okay, that's a security measure basically, right?
Now, go on.
But to do so would result in a user drafting a document of a legal nature engaging in provision of legal services. If you were to convert that PDF document, for example, into a Word document and the advisor starts drafting, then you're in trouble. Okay? That's not your job. Our job is to do the drafting, take instructions off the client at 3, 4, and 5 of that step process.
Perfectly. And so So what we're going to do next week, because we're running out of time, is I'm going to come back and look at this because I would do it completely differently. Because I know this, what I'm going to do next week is look at exactly the same, and I'm going to build a basic spouse will. Now, for the basic spouse will, as I said before, you're not going to have to go through 3, 4, and 5. Because, for example, if I was doing one for Max, he's printing business, it might be easy. If there's no testamentary trust, then I wouldn't need to do that. And we've got that inbuilt protection, as Tony said. But as soon as we know there's challenges and all that stuff, then we go through that 3, 4, and 5. What we're going to do next week, we're going to come back, do a review, take any of your questions, because I'm sure you've got some. But importantly, what I'm going to do, and Tony's going to do, is we're actually going to do a protector and transfer that commercial property into a leading member trust. And then we're going to do basic wills, because at the end of the day, there's not going to be much left. We're even going to, listen to this, we're going to take the equity out of the house that they own and also put that into a trust. And we're going to start to use basic wills. So it's a lot more valuable strategy. And you're going to find it gives you 2 completely different scenarios. And we're also going to look at SMSF wills and SMSF death benefits trusts. So that's next Thursday. So make sure you sign up for that. As I said, the main thing is we've got a lot of stuff coming down the track. Get out to your clients, start using the system, because there's only so much capacity Tony's got, although we do have a couple of other lawyers at Abbott Mourly who we can draw upon. But Tony's number, we'll send you out the slides, 0439 983 720, or tannermorris at abbotmourly.com.au. Or you can easily just go in, for example, if I go and have a look here, if I go to TGA Legal and I've got Tony's, if I've got Tony's email here somewhere, hopefully we've got, there we go. All I need to do is see this little slide here. I just need to follow that link, and then that will take you straight through to Tony's calendar, and you can book that for you. Anyway, we're running out of time. Sorry we went over time, but it's better to get it all packaged up for you. And more importantly, we'll see you next week, because we're going to look at the same case study, but we're going to do it in a completely different way, my favoured way, but that just shows you how we can do wills with testamentary trust. So thanks a lot for that, Tony.
That's all right. And also, if any advisor needs any help or any assistance in answering any questions they're not sure of, give me a call or give me an email. Basically, happy to talk to them about the problem or any issue. Basically, so that way we can resolve it. We can make it much easier. You know?
Perfect. Okay, so thanks for that, Tony.
Okay.
And it's Grant Abbott signing off.
Bye.